Originals under the Rules on Electronic Evidence Bar 2003. 1. Under Sec. 1, Rule 4 of the Rules on Electronic Evidence, the original of the electronic document is its printout or output readable by sight or other means, provided it is shown to reflect the data accurately. Sec. 1 Rule 4, Rules on Electronic Evidence, MCC Industrial Sales Corporation v. SsangYong Corporation, 536 SCRA 408. Section LG Original of an electronic document. An electronic document shall be regarded as the equivalent of an original document under the best evidence rule if it is a printout or output readable by sight or other means, shown to reflect the data accurately. 2. The copies of the printout or output readable by sight referred to in the immediately preceding paragraph are also deemed originals where the copies were executed at or about the same time with identical contents, or as a counterpart produced by the same impression as the original or from the same matrix, or by other means and which accurately reproduces the original. Sec. 2 Rule 4, Rules on Electronic Evidence. SEC. 2. Copies as equivalent of the originals. When a document is in two or more copies executed at or about the same time with identical contents, or as a counterpart produced by the same impression as the original, or from the same matrix, or by mechanical or electronic re-recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduces the original, such copies or duplicates shall be regarded as the equivalent of the original. 3. For the court not to consider the copies mentioned in the immediately preceding paragraph as having the same effect as originals, a genuine question as to the authenticity of the original must be raised, or that the circumstances would make it unjust or inequitable to admit the copy in lieu of the original. Sec. 2 Rule 4, Rules on Electronic Evidence. The applicable rule provides. SEC. 2. Copies as equivalent of the originals. Notwithstanding the foregoing, copies or duplicates shall not be admissible to the same extent as the original if a genuine question is raised as to the authenticity of the original, or b in the circumstances it would be unjust or inequitable to admit a copy in lieu of the original. Original printout of facsimile transmissions Bar 2012. 1. Is a printout of a facsimile transmission an electronic data message or electronic document? This question was answered by the Supreme Court in MCC Industrial Sales Corporation v. SsangYong Corporation, 536 SCRA 408. The court, in this case, concluded that the terms electronic data message and electronic document, as defined under the Electronic Commerce Act of 2000, do not include a facsimile transmission and cannot be considered as electronic evidence. It is not the functional equivalent of an original under the best evidence rule and is not admissible as electronic evidence. Accordingly, the congressional deliberations on the Electronic Commerce Act show that when Congress formulated the term electronic data message, it intended the same meaning as the term electronic record in the Canada law, which excludes telexes or faxes, except computer-generated faxes from the term electronic data message. The court explained that since a facsimile transmission is not an electronic data message or an electronic document, and cannot be considered as electronic evidence by the court, with greater reason is a photocopy of such fax transmission not electronic evidence. 2. In Garvita v. Sales Jr. 271 SCRA 767, the court explained the unacceptability of filing pleadings through fax machines. In so doing, the court ruled, A facsimile is not a genuine and authentic pleading. It is, at best, an exact copy preserving all the marks of an original. Without the original, there is no way of determining on its face whether the facsimile pleading is genuine and authentic and was originally signed by the party and his counsel. It may, in fact, be a sham pleading, underscoring supplied. D. Parole Evidence Rule. Rule 130. Contracts and the Parole Evidence Rule. 1. Among the various evidentiary rules, it is the parole evidence rule that has direct application to the law and contracts. The rule, however, applies only to contracts which the parties have decided to set forth in writing, i.e., as Sec. 9 of Rule 130 provides, when the terms of an agreement have been reduced to writing. Hence, when the agreement is merely oral, the parole evidence rule should not be applied. 2. A contract is a meeting of the minds between two or more persons. This is how a contract is described under Art. 1305 of the Civil Code. The Civil Code does not define a contract as a document, a deed, or an instrument. The document, deed, or instrument is merely the tangible evidence of a contract. It is the meeting of the minds between the parties that constitutes the contract. 3. Before executing a written agreement, the parties normally engage in preliminary oral negotiations. They may even exchange letters or notes constituting offers and counter-offers which, of course, are not intended to be contracts in themselves but are merely parts of the negotiation process. When the minds of the parties finally agree on the object and cause or consideration, a contract is born. In legal parlance, a contract is perfected. The perfected contract may be oral or written, or partly oral and partly written. The form of the contract, as a rule, does not matter. As long as there is a meeting of the minds, there is a perfected contract. Even a purely oral agreement does not negate the existence of a contract because under this jurisdiction, even an oral agreement gives rise to a contract. There is a contract because there is a meeting of the minds. See Arts. 1305 and 13159 Civil Code of the Philippines. 4. The decision of the parties to reduce the agreement in written form is critical to the application of the parole evidence rule. When they execute a written contract, the parole evidence rule ipso facto comes into play. Under Sec. 9 of Rule 130, when the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon and there can be, between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. See Sec. 9 Rule 130, Rules of Court, Carganillo v. People, cr. Number 182424, September 22, 2014. Application of the Parole Evidence Rule, Bar 1978, 1981, 1983, 2012. 1. The Parole Evidence Rule is embodied in Sec. 9, Rule 130 of the Rules of Court which provides, SEC. 9. Evidence of written agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon and there can be, between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. However, a party may present evidence to modify, explain or add to the terms of the written agreement if he puts in issue in his pleading, a, an intrinsic ambiguity, mistake or imperfection in the written agreement, b. the failure of the written agreement to express the true intent and agreement of the parties thereto, c. the validity of the written agreement, or d. the existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. The term agreement includes wills. 2. The term parole evidence means something oral or verbal but, with reference to contracts, it means extraneous evidence or evidence aliunde. Black's Law Dictionary, 5th ed., pp.1005, 1006. As used in the Rules of Court, the term refers not only to oral but also to written evidence which are outside of or extraneous to the written contract between the parties. 3. The Parole Evidence Rule becomes operative when the issues in the litigation are the terms of a written agreement. In clear-cut language, the basic question that would bring the Parole Evidence Rule into play is, what have the parties agreed upon? The appropriate answer would be, look into the written agreement and not elsewhere because only the contents of the written agreement are admissible in evidence. There is no need to look into any other source because such sources are barred by the rule. They are barred because, as Sec. 9 of Rule 130 provides, the writing is considered as containing all the terms agreed upon. 4. The provisions of Sec. 9 of Rule 130 consider the written agreement as the embodiment of all the terms agreed upon by the parties, i.e., a total integration of said agreement. Because the writing is considered as containing all the terms of said agreement, the traditional distinction between partial and total integration observed in traditional American jurisprudence appears irrelevant to the application of the Parole Evidence Rule in a Philippine setting. In American jurisprudence 29 AMUR 2D sections 1116 to 1120, when a writing is on its face incomplete, said writing is only a partial integration of the agreement of the parties, hence, parole evidence is not barred to prove matters not covered by the writing. Parole evidence is, however, barred when the writing is a total integration of the agreement. Under the rules of court, the written agreement is already considered to contain all the things agreed upon. If this be so, the written agreement already represents the final expression of the agreement of the parties on the subject. Being the final agreement, any extraneous or parole evidence is inadmissible for any of the following purposes: a. Modify, b. Explain, or c. Add to the terms of the written agreement. 5. The parole evidence rule, therefore, forbids any addition to, or contradiction of, the terms of a written agreement by testimony or other evidence purporting to show that different terms were agreed upon by the parties, varying the purport of the written contract. See Oil Petroleum Corporation v. Autocorp Group, 569 SCRA 387. Whatever is not found in the writing is understood to have been waived and abandoned. Edrada v. Ramos, 468 SCRA 597. 6. In general, the parole evidence rule is designed to give certainty to written transactions, preserve the reliability and protect the sanctity of written agreements. The rationale behind the foregoing rule was explained in Ortufis v. Court of Appeals 266 SCRA 561. Thus, spoken words could be notoriously undesirable, unlike a written contract which speaks of a uniform language. Thus, under the general rule in Section 9 of Rule 130 of the Rules of Court, when the terms of an agreement were reduced to writing, as in this case, it is deemed to contain all the terms agreed upon and no evidence of such terms can be admitted other than the contents thereof. See also Spouses Paris v. Kimwa Construction and Development Corporation, Gr. Number 171601, April 8, 2015. 7. Be it noted again that the parole evidence rule does not apply to oral agreements. For the said rule to apply, there must be a writing. Not all writings, however, will trigger the application of the parole evidence rule. That writing must embody an agreement. The tenor of Sec. 9 clearly uses the following words: when the terms of an agreement have been reduced to writing. There is only one writing which, although not legally an agreement, is considered to be one for purposes of the application of the parole evidence rule. This writing is a will. The last paragraph of C.9 of Rule 130 confirmed this observation, thus, the term agreement includes wills, italics supplied. 8. Should the writing that embodies the agreement of the parties be in a particular form? Note that Sec. 9 of Rule 130 only makes reference to a writing, not a public writing or a private writing. One case particularly well illustrates the answer to the question. In this case, the petitioner contends that since the promissory note is not a public instrument with the formalities prescribed by law but a mere commercial paper, parole evidence may overcome the contents of the promissory note. The Supreme Court did not view the argument with merit and held that the rule does not specify that the written agreement be a public document. The court stated in the case, what is required is that the agreement be in writing, as the rule is in fact founded on long experience that written evidence is so much more certain and accurate than that which rests in fleeting memory only, that it would be unsafe, when parties have expressed the terms of their contract in writing, to admit weaker evidence to control and vary the stronger and to show that the parties intended a different contract from that expressed in the writing signed by them. Thus, for the parole evidence rule to apply, a written contract need not be in any particular form, or be signed by both parties. As a general rule, bills, notes and other instruments of a similar nature are not subject to be varied or contradicted by parole or extrinsic evidence. In Siong Jr. v. Court of Appeals, Gr. Number 96405, June 26, 1996, 247 SCRA 578. Application of the rule only to parties and their successors in interest. 1. The parole evidence rule does not apply to persons who are not parties to a deed and do not base their claim on it. Eagle Ridge Development Corporation v. Cameron Granville 3 Asset Management, Inc., 741 SCRA 557. 2. Only the parties and successors in interest are bound by the parole evidence rule. The rule that the terms of an agreement are to be proven only by the contents of the writing itself refers to suits between parties and their successors in interest. Sec. 9 Rule 130, Rules of Court. The rule does not bind suits involving strangers to the contract. It applies only to the parties to a written agreement and those who are privy to a party or successors in interest. 29 Am Ure, Evidence, 51096. Thus, a total stranger to the writing is not bound by its terms and is allowed to introduce extrinsic or parole evidence against the efficacy of the writing. Lechugas v. Court of Appeals, 22 Phil.310, August 6, 1986, citing Horn v. Hansen, 57 NW 315. Application of the rule to wills. 1. The parole evidence rule applies to contractual obligations. However, by the explicit provision of Sec. 9 of Rule 130, the term agreement includes wills. There can, therefore, be no evidence of the terms of the will other than the contents of the will itself. 2. While the parole evidence rule applies to wills, an express trust concerning an immovable or any interest therein may not be proved by parole evidence. Art. 1443, Civil Code of the Philippines. Illustration: Mr. Seller and Mr. Buyer entered into a written contract for the sale of a house and lot. The deed of sale mentions a purchase price OFP 25 million, a down payment of 70%, and the balance payable within 1 year from the tender of the down payment, although the actual period agreed upon orally was 2 years. The oral agreement between them also considered the air conditioners inside each room of the house as part of the purchase price, but this fact was inadvertently not mentioned in the written agreement. Under the parole evidence rule, Mr. Buyer would not be allowed to show that the purchase price included the air conditioners and that the payment period for the balance 2 years. He would not be allowed to do so because of the rule that the only evidence of the terms of the agreement between the parties shall be the contents of the written agreement itself. Any extrinsic evidence, therefore, that would modify, explain or add to the writing would be deemed parole evidence and hence barred. Parole evidence is inadmissible to establish stipulations other than those contained in the writing. Thus, all other evidence of the contents of the writing are to be ignored. This is the general rule. When and how to introduce parole evidence. 1. The rule prohibiting parole evidence is not absolute. A party may present evidence when he desires to modify, explain or add to the terms of the written agreement. Carganillo v. People, GR number 182424, September 22, 2014, by putting in issue in the pleadings any of the following: an intrinsic ambiguity, mistake or imperfection in the written agreement. B. The failure of the written agreement to express the true intent and agreement of the parties thereto. Sabarola v. Suarez, 558 SCRA 135. C. The validity of the written agreement, or D. The existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. Sec. 9 Rule 130, Rules of Court. 2. Introducing parole evidence means offering extrinsic or extraneous evidence that would modify, explain or add to the terms of the written agreement, but parole evidence may only be allowed if any of the matters mentioned above from A to D is put in issue in the pleadings. Carganillo v. People, number 182424, September 22, 2014. Without complying with this requirement, i.e., putting an issue in the pleadings, parole evidence cannot be introduced. Example: seller sues buyer for PHP 300,000.00, an amount representing the unpaid balance of the price of a car bought by and duly delivered to the latter. Although deed of stipulated a contract price of PHP 700,000.00, the actual oral agreement was only for buyer to pay a price of PHP 400,000.00, an amount already paid. The amount as written in the deed of sale was actually a result of mere inadvertence. If buyer wants to prove during the trial that the true price as agreed by the parties is P 400,000.00, buyer must allege in his answer to the complaint that there was a mistake in the writing and it does not reflect the true agreement of the parties. Such allegations would put such matters in issue in the pleading, opening the door to the introduction of parole evidence. 3. To reiterate, the parole evidence rule does not per se bar the introduction of parole evidence as long as the pleader puts in issue in the pleading any of the matters set forth in the rule, such as the mistake or imperfection of the writing, its failure to express the true agreement of the parties, or the existence of subsequent agreements. The key words are putting in issue in the pleading. Unless duly pleaded, a party will be barred from offering extrinsic evidence over the objection of the adverse party. Thus, it was clearly declared, provided that a party puts in issue in its pleading any of the four items enumerated in the second paragraph of Sec. 9. Rule 130, a party may present evidence to modify, explain or add to the terms of the agreement. Spouses Paris v. Kimwa Construction and Development Corporation, GSR, number 171601, April 8, 2015. 4. In an action to recover from an insurance policy, the plaintiff wanted to put forth a witness who would testify as to the actual terms of the contract of insurance as allegedly agreed upon despite contrary provisions in said policy. The testimony was not allowed. The Supreme Court sustained both the trial court and the Court of Appeals on the basis of Sec. 9 of Rule 130. The court ruled that Sec. 9, Rule 130 of the Revised Rules of Court expressly requires that for parole evidence to be admissible to vary the terms of the written agreement, the mistake or imperfection thereof or its failure to express the true agreement of the parties should be put in issue in the pleadings. As correctly noted by the appellate court, the plaintiff failed to raise the issue of an intrinsic ambiguity, mistake or imperfection in the terms of the insurance policy, or the failure of said contract to express the true intent and agreement of the parties thereto in its complaint. There was, therefore, no error on the part of the appellate court when it affirmed the RTC's order disallowing the witness to testify as to the alleged terms of the contract. Pilipinas Bank v. Court of Appeals, 341 SCRA 527.